So good morning. My name is Katrina Walasik, and this is Andrea Douglas, and we are two of EBG's associates in the Los Angeles office. And we'll be talking to you about the training options for hospitality employers in light of the Me Too movement and the traction that it's gained in the past few months. So as you all know, the Me Too movement has become extremely prevalent and has gone viral in all senses of the word after several women in the entertainment industry spoke out about and against the prevalence of sexual harassment and sexual assault in the workplace. Now, like the entertainment industry, many employers in the hospitality industry have people who work in non-traditional workplaces, meaning there are no offices, no cubicles, and effectively no functional barriers to protect an employee's personal space. Instead, more analogous to entertainment industry jobs, a lot of hospitality jobs require close interpersonal interactions with both coworkers as well as customers. And as a result, because many of the typical barriers are blurred in the hospitality industry, there may be a higher prevalence of harassment claims and issues that employers should be aware of. A recent EEOC report actually stated that sexual harassment is a serious problem for women, specifically working in the hospitality industry, due in part to the unusual hours and conditions of work, the interactions of persons in the delivery service, and traditional personnel practices in this industry. In fact, the EEOC's data further indicates that they actually field more sexual harassment charges from the hospitality industry alone than any other industry. So what this means for employers in the hospitality business is that you've probably seen or should expect to see a higher number of workplace harassment complaints. In order to be proactive, it's extremely important for employers to be mindful of how powerful training can be when used as an effective tool to both empower supervisors, managers, as well as employees in order to prevent and correct harassment as part of a more comprehensive anti-discrimination program. But really, in order to be effective, the training administered should be specifically tailored to your workforce and their particular working environment. Apologies. The EEOC also recently found that traditional anti-harassment training has not been as effective as we would have hoped because it doesn't act as a truly effective tool against workplace harassment. In fact, a majority of the EEOC trainings that were surveyed actually were focused on reducing employer liability as opposed to creating a more holistic and respectful workplace environment. So in many circumstances, these programs did very little to actually change employee behaviors and instead reinforce gender stereotypes and issues that are cause for concern. Thus, instead of providing training just for the sake of training, employers should focus their training on providing the right, most effective type of training for their employees. There are 4 types of training that Andrea and I will be briefly discussing today. They include quality training, supervisor empowerment training, bystander intervention training, and workplace civility training. So these are all specifically tailored based on what type of workplace that you have and also what you think your employees are going to be most responsive to, depending, of course, on their demographic and also what message will come through most clearly for them.
And so one of the things that the EEOC found is that the employers really need to focus on the quality of the training that they're providing. In the past, anti-harassment training, as Katrina said, is focused on compliance and avoidance of liability. Quality training, however, goes far beyond that aim. In fact, research has shown that the most effective training is at least 4 hours, is in-person, interactive, and tailored for the particular workspace. So, for example, a restaurant's training would differ from a law firm's training by providing examples of situations likely to be encountered in each industry. a server encountering a harasser while passing by in the kitchen, as opposed to an attorney harassing a subordinate. It's best if the training is done by the employee's supervisor or an external expert, as opposed to an HR official with no direct oversight of the employees. Effective training must do several things. First, it must address the behaviors that the employer considers unacceptable. Now, importantly, this is different and often greater than what's illegal. Bullying is great. An employer finding bullying an unacceptable workplace behavior that could lead to unlawful harassment is different than training that focuses solely on the legal liability and legal aspects. The training has to identify the consequences for engaging in the harassment, in the unacceptable behavior. For example, it could include discipline up to and including termination, and or legal consequences if it rises to, if the behavior rises to an illegal level. The training must also identify internal and external resources for employees experiencing or observing harassment. One of the things that the EEOC found is that many people didn't know where to go with a particular complaint. One thing that's been interesting is that studies have shown that the identity of the trainer may impact the efficacy of the training. A recent paper found that women and minorities are actually penalized in performance reviews for supporting diversity initiatives, while white men are taken more seriously when they do so. Another found a backlash against training when the training was performed by a woman rather than a man. Studies have shown that it seems to help when white men are directly involved in the training. Training should be mandatory and it should be frequent. Training should be done certainly initially upon hire, and retraining should occur at least annually. Employers should make an effort to have these topics come up in conversation, whether about strategy or customer service, to incorporate the message into the workplace. This is really about changing hearts and minds at this point, and thinking that you can change that in a one-hour session is unrealistic. This is not something where you can just order some bagels and have people sit down and hope that this is all going to go away. Finally, training needs to be evaluated to determine whether the behaviors have been changed or what needs to be done to make the training more effective. Next slide, please. And so the first type of training that we want to talk about is supervisor empowerment training. As I said, harassment prevention involves changing a workplace culture and practices, and that change has to start at the top. So the organization's highest leadership must make clear that harassment in any form is unacceptable, is taken seriously, and the employer must commit appropriate time and resources to implementing strong prevention and response strategies. The most effective way to create a workplace free from harassment is to empower your supervisors and give them the tools they need to identify warning signs and follow proper protocols for prevention. Managers and supervisors should receive additional training, separate and apart from what line employees receive, about their increased responsibility under the law and under the employer's policies to prevent and remedy harassment. Training should translate those duties to concrete steps to be taken to prevent and remedy harassment and identify the consequences to a manager for failing to do so. One of the things that's notable about the hospitality industry is that these lines can be blurred between supervisor and subordinate. Many times the jobs in the hospitality industry involve alcohol, outside socializing, young employees where this might be their first job, and employees from different cultural backgrounds. Sometimes a supervisor doesn't necessarily see themselves as a supervisor and wants to be the friend of the line employee and maybe reticent to report harassment. One of the things that the EEOC has suggested is to encourage supervisors to report harassment is something that's sort of counterintuitive, and that is to reward managers initially if harassment complaints increase in their departments, meaning that employees have faith in the system to come forward and actually report claims so that the manager doesn't feel that they're going to be penalized for having more harassment complaints in their particular division. Training to empower supervisors should also delve into the definition of sexual harassment and provide examples. Again, these examples should be tailored to the industry in which the employees are working, and it should also provide an explanation of legally protected categories, information on retaliation, and where to go to report complaints? What do you do once an employee comes to you with a complaint? Where does that get referred to?
So another type of training that is found to be extremely successful in the hospitality industry is known as workplace civility training. So what that means for those of you who use a program like Safe Start, for example, for your safety training, this premise will be very familiar to you. And what it is it focuses more on a holistic, common sense approach to workplace civility in order to decrease evidence and circumstances that may lead to harassment. So really, it's more of an approach to create a better working environment by essentially making employees more mindful and more aware and also more respectful overall of all people and not just their coworkers. So the idea behind workplace civility training is essentially to create an effective and respectful workplace. The reason that this is particularly effective in the hospitality industry is because a lot of the tasks and a lot of the examples that are given to employees during this type of training can also be extended to customer service and actually can increase and encourage better customer service, better teamwork, and can generally improve the morale in a working environment. So it's not specifically focused on sexual harassment or harassment treatment within the workplace, but rather how to react to people, how to respond in stressful situations, how to react if you feel as though you're being cornered or you're in an uncomfortable situation. And really the examples are more real-world focused on how people can better handle themselves and adapt to the situations in the world around them, not just confined to the workplace.
Another interesting idea that's been discussed by the EEOC and is being proposed to employers is something called bystander intervention training. Bystander intervention training is different than traditional training in that it equips everyone in the workplace to stop harassment instead of offering only two roles, which are victim and harasser, and nobody wants to play either of those roles. This form of training is still rare in corporate America, but it's been effectively used on college campuses and in the military and by some nonprofits. Studies have shown that soldiers who received this kind of training were significantly more likely than others to report harassment when they saw it. Another found that it actually changed college students' attitudes towards sexual violence and an individual's ability to stop it. And this change was measurable both immediately and a year after. Bystander intervention training focuses on what somebody can do when they see harassment, the see something, say something type of training. Most trainers don't advise that a bystander confront a harasser right in the moment because it can put the bystander in jeopardy. Instead, trainers suggest that a bystander can say something like, in response to a joke, that joke wasn't funny. Another option is to disrupt the situation by loudly dropping a book or asking the victim to come to the conference room. Some people may have seen a video that was shared on YouTube of a man referred to as Snack Man diffusing a fight on a New York subway train by standing between the two combatants and deciding to eat potato chips. Observers can also talk to the harasser later and by asking questions but not lobbing accusations. Saying things like, were you aware of how that came off in that conversation? Researchers also suggest talking openly about unacceptable behavior with colleagues. Like, did you notice that? Am I the only one who saw that? Am I the only one who sees it this way? One crucial element of bystander intervention training is to talk to targets of harassment who often feel isolated. The observers might not know if they thought the interaction was consensual or amusing. And so the colleague could say to the person to whom the harassment is being directed, I saw that happening. Are you okay with that? And if not, they could offer to accompany the victim to the Human Resources Department.
So that's all. If you have any questions, I believe we're reserving questions for the end of the webinar. Thank you.
Thanks so much, Andrea and Katrina. That was a great presentation. I'll add that, and we do have one question, and I'll also add that our audience today is welcome to submit questions directly to us following the webinar, and that information, those questions can be used through the Q&A feature provided by WebEx. We do have one question, which is, won't the recommended training result in an uptick of harassment complaints?
Actually, that's a great question, and actually it may result in an uptick in harassment complaints. And initially, that's to be expected, and that is okay. That would demonstrate that employees feel safe and they feel comfortable, and that the training has actually been effective in rooting out the unwanted behavior. And so in the short term, this is something that employers should actually be looking for.
Right, and additionally, complaints aren't something to be afraid of. If an employee comes to you and allows you to address the problem as the employer initially, then you can be proactive about ending the behavior, about addressing the concern, and will minimize your risk of facing a lawsuit down the road.
Great, thanks so much for that response, and now we're going to turn it over to Amanda for her presentation.
Great, thanks. So I'm going to be talking about expanding sex discrimination protection to LGBT employees in the hospitality industry. So in any conversation about expanding protections in the workplace, including, of course, the hospitality workplace, it makes sense to start with a conversation about Title VII. As I'm sure you all know, Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, religion, national origin, etc., and most importantly for our conversation today, prohibits discrimination on the basis of sex. It does not, however, include sexual orientation or gender identity in its purview, and until pretty recently, courts have been pretty adamant about that reading. What Title VII does offer, however, is protection against gender stereotyping and against sexual harassment, even in situations where it's a case of same-sex sexual harassment. There's two pretty important cases that establish the inclusion of gender stereotyping and same-sex bullying or harassment under the umbrella of Title VII, which are useful to briefly consider because until recently, these have been the best recourses for LGBT folks dealing with discrimination in the workplace because of their sexuality or gender identity. So in Price Waterhouse, Ann Hopkins was discriminated against. Specifically, she was passed up for a promotion because she didn't act enough like a woman. And if you're familiar with the case, you'll recall that men in her workplace suggested that she needed to go to charm school. I quote, she supposedly needed to walk more femininely, talk more femininely, dress more femininely, wear makeup, have her hair styled, and wear jewelry. And the outcome of this case created protection for both men and women that respectively fail to act like men or fail to act like women in the workplace, or that otherwise don't fall into gender norms. Its application to sexual orientation is interesting, though, because it demands a certain conflation of gender and sexuality and relies pretty heavily on the assumption that gay men are inherently more effeminate and that lesbians or queer women are inherently more masculine of center. And while this is certainly useful to some LGBT folks who are seeking protection under Title VII, it also leaves out folks whose gender presentation might be more normative or traditional. The other case on call is a little different. In this case, a plaintiff who was a man who works on an oil rig was mercilessly bullied and harassed by his male coworkers, and a lot of this harassment involved assorted kinds of gay innuendo. And the court notably ruled that this treatment was a violation of Title VII and expanded harassment to mean both harassment in the traditional way that we think about it, as rooted in sexual desire, but also harassment because of sex, right? So in this case, the plaintiff wouldn't have been harassed in the same way if he was a woman who had assorted kinds of, feminine characteristics, but because he was a man, he did face this kind of harassment. The way that these laws have played out and continue to play out in some jurisdictions today is really quite messy, because courts are undecided about where gender stereotyping discrimination ends and sexual orientation discrimination begins, which makes sense because the distinction can be quite blurry. There's also not a consensus about how transgender folks fit into this matrix of discrimination based on gender stereotypes or discrimination based on sex. It's a pretty pressing question, though. In 28 states, employees can still be fired for being gay, lesbian, or bisexual, or otherwise queer, and in 30 states, employees can be fired for being trans. So although there isn't any kind of national protection, the EEOC has been enforcing gender identity and sexual orientation claims under Title VII for a number of years. Back in 2012, there was a case called Macy v. Department of Justice, in which the EEOC advanced the theory that discrimination against a transgender individual because that person is transgender is, by definition, discrimination on the basis of sex and a violation of Title VII. And in 2015, another case similarly ruled that restricting a trans employee's use of the restroom, intentionally misusing their pronouns, created a hostile work environment on the basis of sex. More recently, though, in March of 2016, the EEOC filed its first 2 sex discrimination cases based on sexual orientation in the federal court. In these cases, the EEOC argues 3 basic points that we see come up again in subsequent cases. I've mentioned the first one already, which is gender stereotyping. Basically, harassment based on nonconformity with the employer's gender-based expectations of an employee is a violation under Title VII. The second theory that the EEOC advanced is that of associational discrimination, which is exactly what it sounds like. It's a violation of Title VII to discriminate against someone for their association with individuals in a protected class. And finally, this is the theory that I'm going to focus more on. Sexual orientation discrimination is, by definition, discrimination because of sex. It's the sort of but-for cause of the discrimination. And this is a theory that's really at the crux of a lot of the recent cases that we're seeing. As I've mentioned, the question of whether sexual orientation and gender identity is covered under Title VII has been quite divisive. It's actually created a circuit split with the Second and Seventh Circuit both holding that sexual orientation is covered under Title VII. The Sixth holds that gender identity is covered, and the 11th and First Circuit have come out the other way. There's actually also been a split between the EEOC and the DOJ, and they came to face off in this first case that I'd like to talk about, Zarda. So in Zarda, a skydiving instructor alleged he was fired for being gay. Actually, a client complained to his employer about his sexuality, which is noteworthy for folks in the hospitality industry. It's important to note that just because a customer is put off by an employee's sexuality or gender identity or expression, that doesn't excuse discrimination on the employer's part. This case, Zarda, applied the 3 theories advanced by the EEOC, most notably the idea that sexual orientation discrimination is discrimination because of sex. So what does this mean? In coming to this conclusion, the court said that sex is inextricably linked to sexual orientation, right? Like they're all tied up together. And that therefore sexual orientation can act as a proxy for sex. The majority opinion explained that it's basically impossible to discriminate on the basis of sexual orientation without taking sex into account. So what this would look like in the workplace is if you wouldn't discriminate against an employee who you perceive to be male for being attracted to women, you can't discriminate against an employee you perceive to be female for also being attracted to women. Okay? In a situation like this, the latter employee would not be subject to discrimination but for her sex, and that would create a problem under Title VII. In the second case that I've included, Harris Funeral Home, a woman was fired from her job after informing her employer that she was trans and was going to start following the women's dress code that the employer provided. The Sixth Circuit affirmed that discrimination on the basis of gender identity constitutes sex discrimination and is a violation of Title VII, and also that religious belief does not give employers the right to discriminate. This question of dress code is also particularly relevant to hospitality employers whose employees might have a uniform. And what it looks like in practice is that if a cisgender woman, for example, wouldn't be fired for complying with the woman's dress code, a trans woman or a gender nonconforming employee similarly can't be fired for complying with the woman's dress code. This is also a good example of why it's actually best practice to just have a gender-neutral dress code. It is quite helpful in avoiding a lot of conflict. So the circuits are pretty split, and the Supreme Court will have to make a move probably sooner rather than later. Right now, the Supreme Court has been silent on the issue, though. They've denied cert in Evans v. Georgia, which is an 11th Circuit case that said Title VII did not include sexual orientation protection. But they'll hear a case, Masterpiece Cake Shop, later this year, which may clarify some of the ambiguous balance between religious beliefs and discriminatory practices that's going on right now. So in the time being, what should folks be doing? Hospitality employers are often doing business in places of public accommodation. So there's probably already some familiarity with discrimination claims on the basis of sexual orientation or gender identity. If you read the Take 5, there was recently a case in Hawaii that said that a bed and breakfast in a private home can't claim a religious right to refuse to rent a room to a couple based on their sexuality. But this trend that we're seeing at the circuit court level should prompt employers to look towards their employee base as well as their patrons, though, as the reach of Title VII hopefully continues to expand to provide increased protection to LGBT employees. So some best practices to take into account. Policies should generally provide protection for sexual orientation and gender identity. To the extent that you haven't already, consider updating handbooks to have harassment and discrimination policies that include LGBT folks. Of course, don't prohibit a trans or gender nonconforming employee from using the restroom of their choosing. To the extent that it's possible, it's always a good idea to have a single occupancy restroom available for really anyone who desires the additional privacy, whether it's a customer or a cisgender employee or a transgender employee. It's important to remember that this is not like a bathroom to like relegate trans employees to. It's available more broadly. It's important to use folks' chosen names, pronouns, and titles. If there's name tags, ensure that it includes the correct name. And if there's a meeting, it's generally like a good practice to have everyone give the pronouns that they use to create that sort of culture of inclusion. It's useful to provide all employees with training that will provide information on gender identity issues, issues surrounding sexuality, and to provide this training to HR personnel particularly. Even if your state or jurisdiction doesn't have laws protecting LGBT employees from discrimination right now, that's certainly the trend that courts are heading towards. So it's definitely helpful for employers to enact policies that prohibit discrimination in the workplace now.
Great. Thanks so much, Amanda, for your presentation. And now we're going to turn it over to Mike McGahan for his on due diligence on labor and employment issues in hospitality.
Good afternoon, everybody. My name is Mike McGahan. I'm a partner at EBG and a member of the labor and employment practice in our New York City office. This afternoon, I want to quickly walk you through what you should be looking at when you're contemplating a transaction, buying, purchasing, becoming a joint member of the ownership or management of a hospitality property, and what you should be looking at in advance so you know what you're getting yourself into when it comes to labor and employment issues. I'm sure all of you have seen a lot of this in both the national press and employment-related news bulletins that are coming through all the time. Some examples of what you can get involved in are wage and hour class actions. We had one matter where employer did not do due diligence in taking on some subsidiary properties and bought themselves into a multi-million-dollar settlement of an ongoing wage hour class action in one of the divisions it purchased, just as a warning as to what can happen if you're not aware of what's going on. Also, you see a lot in the news now about harassment claims. We had some discussion already earlier here about that growing area. Very much in the news, very much something you should be looking at in your potential mergers or purchases or whatever, to see what's going on in the other property, to make sure you know and are aware of what could happen. Unions are a big issue in this area. In hospitality, we've seen an uptick and focus of union organizing. Also, you may be looking at properties that are already organized. What does that mean to you? We'll go over that in a little substantial detail in a few minutes. Discrimination complaints, lawsuits still continue. If those are ongoing, you're going to want to know about them, where they stand, what the possible liability is. Are you walking into a situation that could make you a joint employer or a successor employer that could bring liability that you weren't aware of if you haven't done your due diligence and made a decision? And the last one of my examples here is ERISA withdrawal liability. This has to do with multi-employer pension plans. It's only in a union setting you would find this, but you don't want to be surprised here because withdrawal liability claims can run into many millions of dollars if they're triggered by the transaction that you are contemplating. So we'll take a little bit of a look at that. So types of transactions, almost anything. I tried to be very broad here. Basically, any type of transaction that results in a party becoming the employer, whether it's a joint employer, successor employer, or actual employer of the other party's employees. So any kind of change of ownership, could be a stock sale, could be an asset purchase. In the hotel industry, especially in restaurants, you have a lot of change of managing agents of the hotels without necessarily a change of ownership, but management of a hotel can bring joint employer relationships or maybe even contractual employment relationships, depending on the deal you're involved in. Same thing in joint ventures. So very broadly, you should keep in mind if you're going to have any responsibility for what goes on with the employees of the new entity or the purchased entity or however you come into contact with it, you should be doing due diligence on labor and employment issues in advance. So just to give you an example, some areas of concern you should be looking at, first of all, is statutory compliance. There are a lot of laws now, and they're ever evolving, that govern the workplace. The ones you're most likely to run into are the Fair Labor Standards Act, and we're going to hear more about that later in the last part of our presentation. But there are also state wage and hour laws that go farther than the FLSA, especially when it comes to things like daily overtime or what the minimum wage is. So you have to look at several levels of compliance. So you want to look at, you're looking at another employer, you want to make sure they're complying with this so you're not buying yourself some hidden liability. OSHA, Occupational Safety and Health, something else. Family Medical and Leave Act, FMLA, everybody's familiar with that. There's liabilities there if it hasn't been applied properly. Any of the EEOC laws, and now more increasingly state and local laws, which are becoming broader than the EEOC. One of the things we deal with here in New York is the New York City Human Rights Law, which has sections that say we're to be interpreted differently and more broadly than the state and federal law in this area. So you have to be concerned about where the property is located and what the state and local laws may be that apply. Are there ERISA issues with terms of how they're running their benefit plans? And then, of course, immigration compliance are all areas that bear looking into where there could be a concern about carrying over liability. Moving down to another level, as I already mentioned, state and local labor laws, what we're seeing are new laws affecting tip sharing, tip pools in the workplace that directly affect the hospitality industry. In some locations, we're seeing laws that require accrual and payment of paid sick time outside of union contracts or company policies. Now, here in New York, we even have a paid family leave law, and that is expected to spread throughout other jurisdictions throughout the nation. And there are pending regulations about scheduling and call-in restrictions, and there's actual laws about that in New York City, and pending regulations in the state limiting how you can do on-call or call-in of employees when extra help is needed in a work, especially perhaps in the hotel industry, which can have fluctuations in occupancy up and down. These are going to be very important to keep an eye on, because your staffing that you're always trying to adjust to be the most efficient may run into some problems with these new regulations. And so you'll want to make sure your target property is complying with those, and you're not buying into, number one, possible liability for prior violations, or going forward an increase in your operating costs because you have to adjust to apply with these things. Labor relations are going to go into in more detail in a couple of minutes. Of course, you want to see if there is employment litigation of any nature, either pending or threatened, lawyer letters, anything that could carry over to be liable to the other party to the transaction. Handbooks and policies, are they up to date in all respects? As I said, the law is constantly evolving in these areas, especially in the human rights areas, as we've heard in our earlier presentations today. Are those handbook policies up to date, or there's something in them that's not, that may lead to potential liability down the road? Anti-harassment policies, especially as part of that, you should be looking in detail at what claims have been made, what complaints have been made, how the target property has investigated them, and perhaps even now we're seeing more is looking at existing settlement agreements and whether they're compliant, or do they contain clauses such as non-disclosure clauses that are now under review and attack by the parties that signed them. You may want to know whether you have anything like that in the internal workings of your target property. So just to wrap up, I want to go through very quickly specifically labor relations issues because of the increase of organization in the hotel industry, where you might be facing either a non-union property and you want to see what are the threats facing this property that might result in a union workforce, or if the hotel or the restaurant already has a union workforce, how do I deal with that? What do I look for to see what the problem areas might be? So first, with the non-union workforce, you're looking at the risk that a union will come in and organize the property. And this happens a lot when you have a change of ownership, or the managing agent or the corporate structure somehow changes. Employees are going to be worried about their future in that organization. Am I going to still be employed, being primary among them? And that may lead to the interest in looking for union representation of that workforce. So you need to be sensitive to that and looking at all the other areas. So directly involved in that, you're going to want to ask in your due diligence, are there any petitions filed by unions with the National Labor Relations Board looking to represent any employees? Are there evidence of card signing campaigns by a union, which is the predicate to filing a petition with the NLRB? In the modern age, social media campaigns have become popular. So you want to find out from the target whether they've been the subject of social media campaigns by unions trying to organize. Next thing you look at is the company vulnerable to union organizing? And you may pick that up in the social media campaigns. Are they paying competitive wages and benefits to the area? Are there a lot of employee complaints about working conditions? And going back to all the compliance with statutory requirements, unions use those often as a wedge to get into a workplace, and they will take up like a wage hour claim on behalf of some of the employees and then sell themselves to the rest of the employees as a champion for the working men on these types of issues, and if we came in, we could do that for all of you. Is the property located in an area that in general unions have been looking to organize hospitality properties? We've seen that a lot in the metropolitan area as a result of the neutrality agreement between the Hotel Trades Council in New York and the Hotel Association, which opened up union organizing all through northern New Jersey, the Hudson Valley, Long Island. So you need to be aware of that. Switching over to when the target property is a unionized workforce, what should you be concerned about there in doing your due diligence? Well, first, get the big picture. Are all the employees organized? Do you have only the wait staff organized? Do you have only the kitchen or different segments of the workforce organized? Are they all covered by the same collective bargaining agreement, or perhaps you have several different unions representing different parts of the workforce that you're going to have to deal with? And of even greater concern, where you have some employees are in the union and others aren't, is that going to spread throughout the rest of the workforce? And you're going to have to develop questions about whether employees are satisfied in the non-union areas with their wages and benefits. Or are they all looking over their shoulders saying, well, you gave the union a 3% wage increase, when do we get ours? With the implied threat that they'll go to the union if they don't. Are the unions in the workplace that are there now, do they represent these unrepresented classifications and other properties, which would make them a target for a union organizing campaign? And what communications have the existing employer been making with the workforce about these issues, if any, to get a feel for how the workforce is reacting to it? In any situation where you're looking to get involved with a property that already has a union, you're going to want to look first to their existing collective bargaining agreements, the CBAs. And what are they going to tell you? It's very, very important information. They tell you what the wage rates are. It's usually set forth right in the contract. We'll tell you what the upcoming increases are. 3% next June 1st, 4% the following June 1st, so you'll know. What paid time off are you faced with? It's all spelled out usually in your collective bargaining agreement. Benefits, contributions to pension and welfare funds are usually spelled out. And with the ever-increasing cost of those benefits, they will usually have a schedule of increasing contribution rates over the life of the contract. The contract will tell you what the expiration date is, when you're going to be facing bargaining on everything going forward into the future. You would look to see whether the property is a member of a multi-employer bargaining group, which is bound to a multi-employer contract. And when I say time to get out, there's a limited time window towards the end of every contract that you can pull out of a multi-employer group by notifying the union and the group, and you have to do that before bargaining begins on the next contract. That's why it's important to know when the contract ends, and if you have that window, if that's your desire to get out of the multi-employer group and bargain with the union independently, which is another decision that has a lot behind it and might flow out of all the other due diligence, the decision whether to do that. You would look to see whether the contract has a successorship clause. These clauses are used to protect the union representation, and what they generally require is that when a owner sells the property, that he or she has to secure the agreement to the purchaser, or the purchaser to recognize the union and adopt the collective bargaining agreement. So you certainly want to know if that's in there, and you usually find out when the seller tries to exercise it and says we have to deal with this in the contract. Practically speaking, you have to have legal assistance in this because these clauses are of varying enforceability and some have more teeth than other. And so you could get an opinion as to what the impact of that clause is. Neutrality clause become very popular. The union succeeds in getting an employer to agree that if they try to organize any other parts, bargaining units within a property, or even other properties owned or operated by that entity, that they will be neutral and not fight the union's campaign to organize in those other locations. It's very important to know that before you enter into an agreement. Management rights clause will tell you what rights you have and can exercise while the contract is running without having to get the union's agreement. And of course, you want to make sure it has a no strike clause, which will prevent the union from striking during the life of the contract. There's also some things outside the CBA that bear some looking at. I would suggest getting a list of all the pending grievances, see what the problems are in the workplace. Make sure you get a list of any arbitrators awards where the union or the company has gone to grievance arbitration, and then you may have an award that changes how certain parts of the collective bargaining agreement are interpreted. So you'll want to make sure you know that. And the same impact could be found in side letters between the property and the union, or in settlements of grievances where things within the collective bargaining agreement are changed in some manner. Very important topic to end with here is to make sure you look at the financial health of the multi-employer health and welfare plans you may be contributed to. You may find that beyond the contract, you can expect that there'll be a major increase in contribution costs. You want to make sure it's compliant with the Affordable Care Act. For pension plans, if there's that, you want to make sure you know whether there's the financial status under the Pension Protection Act requires that that plan is under a rehabilitation plan, which mandates increases in contributions every year, sometimes projecting out 5 or 10 years. So you want to know if you're faced with that. You want to make sure that they are current in their contributions to the funds, because under ERISA, the penalties and interest for arrears in payments can be very steep and can increase your costs significantly. And finally, for the multi-employer pension plans, you want to get a reading on whether there is unfunded liability. Because unfunded liability, and most plans carry some unfunded liability, but some are in really bad shape. I've seen plans that are perhaps only 28% funded against what ERISA requires and under rehab plans, and an employer that tries to withdraw from that plan is hit with multi-million-dollar pension liability, withdrawal liability. Basically, withdrawal liability, in a nutshell, is if an employer withdraws from the requirement to pay into the pension plan, they measure the unfunded liability and they measure that employer's proportionate share of that unfunded liability, and then issue them a letter saying, you owe us $20 million, we'll give you 20 years to pay it off at 10% interest. And it's all protected by ERISA, and it's a difficult situation to be in. And oftentimes it's a factor you have to deal with in the transaction itself. In a stock sale, the liability, which wouldn't be incurred in a stock sale, would just be transferred to the owner, and if they withdrew, they could be hit with it. In a sale of assets could possibly trigger it for the seller, and there are provisions in ERISA under which they could try and transfer it, and you may see in your due diligence, you'll want to get into this, if the seller is trying to get this to be an ERISA transfer, the transfer of the withdrawal liability and the obligation to contribute to the pension to the buyer. That's a very complex area that you're going to need ERISA counsel to assist you in, but I just wanted to alert you to why it's so important to know what the funding status of any multi-employer pension plans. And single-employer pension plans have requirements on how well they're to be funded, And if your target property isn't been funding it right, there may be a liability sitting there if you're going to take over operation of that pension plan as part of the transaction. And with that, if we have any questions on this issue, I'd be happy to answer them.
Thanks, Mike, so much. And I think you saved one of the most alarming issues for last in that presentation, but all very important for those hospitality industry employers who are considering a corporate transaction. There's many issues to consider, and by all means, if you have any follow-up questions or want to engage Mike, you should reach out to him, and we'll have his and the rest of our contact information at the back of the slide presentation. But now, with the remaining time we have, my colleague Adriana and I are going to discuss the USDOL's new paid program. Adriana, would you kick it off?
Sure. Thanks, Jeff. So we're going to begin where it seems very logical to. I will first start by telling you what the paid program is, and then we'll take a look at how exactly it works, what the framework is, what the stated purpose is, and who actually can participate in this. And once we cover the basic rubrics of what the paid program requires, I'll turn it over to Jeff, who will then explain that it is not necessarily the safest route for employers to consider, and there are definitely risks to think about before initiating an audit under the paid program, and what to expect going forward. So what is the PAY program? First of all, it's an acronym. It stands for the Payroll Audit Independent Determination Program, which is a long way of saying it's a nationwide pilot which was initiated by the U.S. Department of Labor, the Wage and Hour Division, that is, to allow employers to avoid potential penalties for overtime and minimum wage violations under just the FLSA, the federal statute, by undertaking a self-audit and voluntarily reporting those infractions to the Wage Hour Division using the framework that the PAID program provides. The end goal is for employees to receive 100% of the back pay wages that are owed to them without having to pay any litigation expenses, incur attorney's fees, or have to go through the protracted process of litigating their claims, and for employers on the other side of the table to avoid potential exposure to liquidated damages or civil monetary penalties. And also, there's the incentive for employers to obtain a release from the employee's rights to privately sue the employer for the unpaid wages owed as a result of the specific compensation practice that's at issue. And Jeff will explain in a little while just how limited that release might be. The goals, as stated by the Wage and Hour Division, are to resolve claims for unpaid minimum wage and overtime under the FLSA as quickly as possible without litigation, which will ensure that employees end up receiving the back wages that they are owed more quickly, and also to generally improve employers' compliance with the overtime and minimum wage requirements under the FLSA. So how does the program work? First of all, the employer has to make the decision that it wants to conduct a self-audit of its compensation practices in order to identify what potential violations may be present, or if it believes that it's, complying but wants to double check, to undertake this review, gather information it finds that may reveal potential violations, and identify the employees and the relevant time frames. And from that point, there will then be an assessment of what back wages may be owed. So the first thing to point out is that an employer will be looking at a particular compensation practice. This is not going to be an open-ended self-audit, at least from the employer's perspective. In terms of time frame, the maximum time frame is 2 years. If the compensation practice at issue has existed for a shorter period of time, then that shorter period of time will be the focus of the self-audit. After the employer undertakes its review, it reports to the information that it has gathered to the Wage and Hour Division, What's important to keep in mind here is that the information must be provided with a series of certifications, some of which I'll tell you about right now and some of which we'll discuss on the next slide because they're a little bit more significant. So initially, the employer has to certify that it did review the compliance materials that the Wage and Hour Division has made available primarily on its website. Secondly, the employer has to certify that it is not currently litigating or being investigated for those specific compensation practices that it's taking a look at in this self-audit. And finally, it has to certify that whatever the result of the self-audit is, it will adjust its practices going forward in order to avoid any potential violations for the same practices in the future. After the information is provided to the Wage Hour Division, basically the DOL takes over. It will evaluate the information that it's received. It could, if it wishes, request additional information from the employer if it considers such information necessary to assess the back wages owed. And finally, it will eventually issue a summary of the unpaid wages to the employer with the forms describing the claims releases, which are the settlement forms for each of the employees who is encompassed within this audit. After all of that's finished, the employer then issues prompt payment. Now, the important thing here is that the audit process and the Wage Hour Division review is a supervisory process from the Wage Hour Division perspective. But the Wage Hour Division doesn't issue the payments. It's the employer's ultimate responsibility to do that. So who can participate? Generally speaking, it's all employers who are covered by the FLSA, but this is limited. Like I mentioned earlier, there are certifications that you have to make. If you're litigating or if you're under investigation, you cannot participate. You can't obtain the protections of the program, meaning the claims releases or the avoidance of liquidated damages or civil monetary penalties. The additional certifications are listed here. You have to certify that you are not subject to prevailing wage requirements. You also have to show that you're not a repeat violator, as the Wage and Hour Division would call it. Basically, you haven't been found within the last 5 years, either by the Wage Hour Division or by any court, that you have violated the FLSA, and that you also haven't previously participated in a paid program to resolve these issues. On the employee side, to receive the back payment, you have to sign the claims release, and that's a decision that ultimately rests within discretion of each and every employee. And now I'll turn it over to Jeff to explain why the program may have certain risks that employers certainly should take into consideration before initiating a self-audit.
Thanks, Adriana. So we come to the million-dollar question. Should employers participate in the paid program? The answer that I give to clients is you should have a healthy skepticism of it. You should consider what it is the DOL is offering through it, and then consider whether you believe as an owner and operator if what you can provide to the DOL will put you in a better position by self-reporting than were you to handle the situation privately on your own or take any other steps you may want. Let's first start with the Wage and Hour Division potentially requesting additional information. Now, the Wage and Hour Division for decades has become very experienced and is very good at executing investigations, usually pursuant to whistleblowers or directed investigations. That means that typically uninitiated, the Wage and Hour Division will send through its regions throughout the country investigators to look at employers' pay records to determine whether there is full compliance with the Fair Labor Standards Act. As I said, this usually is initiated by a whistleblower, an employee who's complaining that he or she may not have been paid properly under the Fair Labor Standards Act, or there's some other violation, such as a record-keeping violation that would potentially result in penalties being assessed, or any other compliance issues. Or it could be a directed investigation where the Wage and Hour Division had previously investigated an employer, is aware of that employer, and they will pay a visit upon the employer in the future to determine whether or not that employer has come into compliance since the previous investigation. So with that backdrop, you should understand that if you want to participate in this voluntary program, the employer, the owner-operator, is not going to be able to necessarily control the scope or the flow of the investigation. The Wage and Hour Division is taking this on as a pilot program. It's as new for them as it is for us as owner-operators. So they are really going to be relying on their skills in conducting a general investigation. They're likely not going to limit, at least not from the inception of this program, until they gain some more experience, the scope or focus of the investigation, and it would just be natural, and I would expect nothing less than the DOL from the Wage and Hour Division to ask for all records, all documents, and conduct basically a comprehensive investigation for those employers who are self-reporting. Now, of course, they're likely going to start with the issue that's being self-reported by the employer, but from there, they will probably fact-find. They will likely speak with employers working on site and conducting interviews. They will speak with members of management. They will do a fulsome review of records, and at the end of the day, you're probably going to be looking at the same sort of investigation that one would be a subject of if in fact they had been a subject of a whistleblower complaint. So by self-reporting, you are not necessarily putting yourself in a position as an employer of limiting the issue or otherwise potentially limiting liability, which I'm going to speak about in a moment. In addition to that, once you are, quote, a target, even if it's through self-reporting, the Wage and Hour Division will not waive its right to conduct future investigations. As I mentioned before, the Wage and Hour Division often conducts what's called directed investigations, whereby they will pay visits upon employers to determine recidivism, to make sure that the employers are, in fact, in compliance with all the laws, rules, and regulations pursuant to the Fair Labor Standards Act. So once you are on the DOL's radar screen, so to speak, you will remain there. That doesn't necessarily mean that the Wage and Hour Division is going to call upon you and conduct a follow-up investigation after the statutory period of 2 or 3 years under the FLSA, but they may very well call upon you in the future, and if you do not want to necessarily be subject to such scrutiny through your voluntary actions, you should think twice about voluntary participation in this program. I think it's also important to mention that the U.S. DOL maintains many memoranda of understanding with other state and federal agencies. So not that it's necessarily going to occur, but if you do self-report and there are findings and there's violations of the FLSA, there might be certain other issues that could result in a referral to another governmental agency. For example, in the case of misclassification, where someone was being utilized by an owner-operator as an independent contractor, which we see very frequently in the hospitality industry, such as housekeeping and other outsourcing, that issue can result in other issues, legal issues, such as benefits, tax classification, tax payments. And so were the DOL to find misclassification for wage and hour purposes, I'm not suggesting that they would automatically make a referral to perhaps EPSA under the DOL for benefits purposes, or perhaps the IRS for tax-related purposes, but it certainly is possible. Likewise, many state agencies have memorandum of understanding with the U.S. Department of Labor as well. So where certain states, such as New York, California, Massachusetts, Illinois, many others, increasing throughout the country, have greater worker protection and employee friendly and protective statutes and regulations, there certainly can be greater liability than that which the DOL assesses under the Fair Labor Standards Act. Always remember, the FLSA is a floor. There are greater protections in all varieties, especially with respect to hospitality, especially in tip earning scenarios, as we all know, where you have to be mindful not just of the FLSA, but the state rules and regulations. For example, in New York, which carries a 6-year statute of limitations under the New York labor law, So to the extent that, let's just say, there was overtime reconciliation with the Wage and Hour Division for purposes of FLSA compliance, well, there may be a balance of 4 years of noncompliance under the New York labor law. And so there very well could be follow-up investigations by the New York State Department of Labor, or perhaps through a private plaintiff's attorney who is going to seek out greater relief. Remember, if there is a finding and there's a voluntary payment, those payments, of course, will go to your staff. If your staff is receiving a check, they will likely ask questions. If they ask questions of legal counsel or others not understanding why exactly they were paid, they may be informed that they're entitled to even more money under the statute of limitations, perhaps under other violations, which the Wage and Hour Division are not going to look at because it's not within their jurisdiction. Again, they're limited to the FLSA and its implementing regulations. They're not going to investigate the New York labor law. While we're discussing state, there are other potential state issues which you have to keep in mind. For example, where you have the New York Department of Labor who looks at these issues closely, especially issues such as misclassification, you don't have the same type of protection that you would have through the Wage and Hour Division with a release. You are not releasing your claims, or excuse me, the employees are not releasing their claims against you, the owner-operator, for all purposes and all laws. It will be very narrow. It will be very limited. So you're not going to find yourself in a safe harbor should you voluntarily self-report to the DOL. And those are, for the most part, some of the main issues you want to consider before participating in the pilot program. One other point I'll mention, and this is somewhat related to the DOL making, calling upon the employer later on or revisiting, is the idea of willfulness. So as Adriana explained, it's a 2-year statutory period that the Wage and Hour Division will look back upon for purposes of compliance under the FLSA. The FLSA also carries a 3-year statute of limitations for willful violations, willful being defined as knew or should have known that the employer should have been in compliance with the Fair Labor Standards Act. So by self-reporting, you are essentially checking the box on knew or should have known. So should there be a revisit, that revisit will be with respect to the 3-year statute of limitations in all likelihood, which means greater possible liability. If we could just turn to the next and last slide, as I mentioned, as Adriana mentioned at the outset, this is a 6-month pilot program. We're all in uncharted waters, and for the reasons that I provided, we want to think long and hard about whether we want to voluntarily participate. Adriana mentioned that one of the incentives that the Wage and Hour Division provides is to avoid potentially civil money penalties, which are enforceable pursuant to regulation, as well as liquidated damages. And just a word on liquidated damages, under the Fair Labor Standards Act, which imposes liquidated damages, it's considered time value or basically interest bearing on the time from when an employee should have been paid back wages, even if there was an inadvertent underpayment. Willful is not tied to liquidated. It's statutorily imposed. Typically, when we think about an investigation and I'm not talking about pursuant to the voluntary pay program, but an investigation such as a whistleblower or a directed investigation, the Department of Labor is most interested in back wage assessment and recovery. Civil money penalties are important because it's what keeps the operation going, so to speak, and it helps the Treasury and the budget. But at the end of the day, it's about getting the money back in the hands of the employees. So when you are negotiating a regular back wage finding or reconciliation pursuant to your garden variety investigation, it is very common that the DOL will in fact negotiate civil money penalties with the employer if they are willing to come into compliance. Similarly, with liquidated damages, it is rare that liquidated damages are assessed at the administrative level. Liquidated damages are typically reserved for administrative enforcement proceedings by the USDOL through its solicitor's office, which is based on the region, and which I'm a former member of, as well as in private lawsuits. you typically don't see liquidated damages being assessed at the administrative level. So it's somewhat of an empty incentive for the Department of Labor or the Wage and Hour Division to tout the pay program because of the potential avoidance of civil money penalties or liquidated damages when they may not have been assessed in the first place were there to be a traditional investigation without having to self-report. And I'll just end by pointing out sort of something a bit practical and something that I typically do with clients, which is self-auditing, working with owner-operators to identify potential issues. We know in hospitality there tends to be a lot of attrition, and with attrition there tends to be realignment of jobs, which means job descriptions change, duties change, and the rest of it. So we'll look at classification, whether it's independent contractor classification as opposed to being an employee, or we look at the bona fide exemptions pursuant to administrative, executive, and professional. Hospitality, we're usually talking about executive, the managerial exemptions that's available to determine whether or not there's full compliance. Same thing goes for off-the-clock work, record keeping, and the rest of it. And so it's okay and, in fact, encouraged to do a self-audit. If you find that there was an underpayment, it's also okay to assess and make a reconciliation voluntarily to your workforce for up to and including the full extent of the statutory period. And there's good communication and talking points that we here work with employers, owner-operators, on how to message it so that you avoid further liability, further scrutiny, and you maintain good employee relations. This can all be done without the assistance of the DOL. And so if you have doubts or concerns, or you just want to, quite frankly, look under the hood of your workforce to make sure there's full compliance, it's always best to start privately, internally, work with outside counsel, which I encourage, and then make a determination as to how you want to handle it. You may get a release with the DOL, which is quite helpful, but again, for all the reasons we described earlier today, it's a limited release, and you will not necessarily be reporting to the DOL, and you could avoid some further future exacting scrutiny, which I can assure you will be exercised by the DOL, especially when they don't have the resources to do a fulsome investigation, and you've already self-reported, so you're within their purview. So just want to leave you with that. Again, it's a good program, but better to wait, see how the pilot program works out, and we could reassess this in the future if owner-operators feel strongly about participating. So with that comes the conclusion. I know we ran a few minutes over. I don't know if we have a few minutes to spare because I know we have at least one question. Before I get to that, and before I forgot, because there were some housekeeping tips that I forgot at the outset of this presentation, I'll just mention that in approximately 2 to 3 business days following today's webinar, Epstein, Becker, Green will communicate the availability of that webinar recording and access to the PowerPoint materials. And we believe it'll probably be available in roughly 3 to 5 days. One question, and now we have 2 questions, which is great. One question we have, I think, is for Amanda. The question is, our employee restrooms are gender specific, and one must enter through the changing room in order to access the restroom. How do we handle if an employee requests to use based on gender identity?
Okay, so thanks for that question. The short answer is you say, okay, use the restroom. Basically, the idea that folks should be able to use the restroom that best fits their gender identity also applies to any gender-specific facilities, be they locker rooms, changing rooms, and so forth. Of course, like if the employee is a trans woman, let's say, trans women are women and should be able to use the women's changing room or the women's bathroom if they so choose. This is where training is really useful. A lot of the time, employees or other employees just may not have the familiarity with some of these issues, and a lot of the time information can make folks a little bit more comfortable. This is also when single stall bathrooms or changing rooms can be useful if an employee just really feels a type of way they can use the single stall bathroom. But yes, the short answer is that any employee who requests to use the bathroom that best fits their gender identity or the changing room or the locker room should be allowed to do so.
Great. Thanks so much, Amanda, for that response. I know that there was one other question that's in the Q&A section, which I believe has been answered by Katrina, and I think is available for viewing by all of our audience. So not going to repeat that in the interest of time. I'd like to thank everyone for their time today. Thank you to our panelists and our presenters, and thank you most importantly to our guests for tuning in or dialing in for this webinar. Again, it'll be available probably in 3 to 5 days along with the PowerPoint materials. And I just wanted to let everyone know that our next webinar next month will be focused on technology, the technology industry. So you'll receive some emails and updates on that, and we hope you tune in the coming months. Thanks so much.